All right, welcome everyone. Thank you for joining us. And this is a presentation in conjunction with Cummins White Law. My name is Philip Stennis. I represent Cal State Fullerton Startup Incubator. If it is your first time joining us and learning about Cal State Fullerton Startup Incubator, what we do is we help out early stage startup ventures. Those are people who are either looking to take their idea, I say from a napkin, all the way to bootstrapping it and seeking funding. We also help people who are just starting off their business or in revenue already. Basically, we help you out for the next 6 months, and we work with you by assigning you a mentor that works with you on a weekly basis. We have tons of resources such as business attorneys, as we're going to see with Alissa, and I will put more information into the chat. So with that, thank you for showing up today. And Lisa, why don't you go ahead and take it from here?
Hi, everybody. Thank you so much for coming. So my name is Alissa Aguilar, and like he said, I am a transactional attorney at Cummins White. We're outside generalists, so I help companies in various industries, a lot of work directly with the CEOs of companies to kind of get to their financially driven goals while protecting them legally. So that starts with corporate governance to doing contracts, vendors agreements, non-disclosure agreements, everything of that nature. I handle anything transactional is what I personally work on, and we don't really do litigation. And the idea is if you do a good job with the transactional side, you never go to litigation. So that's what we try and do here. Okay, sorry, I meant to go to this slide, but yeah, my concentration is contracts, like I said, transactional attorney. So overview. Negotiating a contract is a collaborative process between the parties, and it's not supposed to be confrontational. So as a basic rule of contract creation, whether you're reviewing or negotiating, it's important to keep in mind that the goal is to come to a mutually agreeable and beneficial outcome. So you guys are going into this with a common goal, and you want to come to an agreement that both sides are happy with. For example, party A is, paying for services, and party B is delivering services. You guys want to come to an agreement on the value of those services and feel like you are coming out of the contract both, on the better side. So it's really important to work with the other side, and in negotiating these contracts, it's not meant to be confrontational. And on top of that, we are trying to protect our client while also maintaining our position. So what is a contract? We could start with the law school definition of a contract. So an offer is meant to be clearly communicated to the offerer. So I offer to sell you 100 widgets. Once an offer has been put out by a party, from one party to the other, either in writing or verbally, the power is going to shift to the acceptor. So acceptance. Acceptance has to be clearly communicated either verbally or in writing to the offerer. So it's important to note that once you've sent out an offer remains open until revoked by the offerer. What you can do, though, as an acceptor is instead of accepting their offer as it is, you can kind of change a term. So if I offer to sell you a car for $500, as the acceptor, you can now say, I will buy your car for $450. So it's important to note that this acceptance actually revokes the original offer, and it changes the power dynamic because you are now the offerer. You've revoked their offer, and now you're offering to buy their car for $450, for example. So offer, acceptance, and then consideration is the last part of a binding contract. Consideration is the value that induces the offerer. It's the value that induces the parties to enter into the contract. So this is what changes a gift, for example, to a contract. With a gift, party A receives a car from party B and gives nothing in return. That's just a gift. It's not a binding contract. But in a contract, party A must exchange something with party B to receive the car. That's the consideration. So the consideration would be the $100 for the widgets. It's what makes the contract legally binding, setting the offer and acceptance into play. The idea is to have a mutual meeting of the minds where the offer is clearly stated and the acceptance is clearly communicated. The consideration, again, is the part that's going to make that binding. So there's different ways to have consideration. It's not always payment. It can be detrimental reliance. For example, if you promise me something, I accept it and rely on your promise, that will also be a legally binding contract. The more useful and kind of practical definition of a contract is a binding agreement through which the seller transfers goods or services to a buyer. It outlines the terms and obligations involved in a new commercial relationship, and it outlines the specific legal responsibilities a buyer and a seller owe to one another. I want to stop right here and see if anybody has questions on this initial idea of a contract and the concept in general.
Feel free to unmute yourself or put something in the chat.
Okay. So now we could go into why we need a contract. So it's very important when you're drafting a contract to be clear about each party's rights and obligations. It's important to note that one party's right is often another party's obligation. So if you're offering, for example, I offer 3 car washes a week to you. As party A, that's your obligation to provide those car washes. It's the right of party B to receive those car washes. Then the payment on party A's part is their obligation to pay for the services. So that's where the whole idea of equity just really comes into play when it comes to contracts, because it's a dual-sided relationship. If one party is agreeing to pay services, it's the obligation of the other party to provide those services. A contract is also really important to prevent miscommunication in the future when you're with a business partner and you guys are disagreeing on terms of a contract. It's really important to be clear in that writing, so that way it's not open to misinterpretation when you go back and you look at that contract. So it's just very important that everything is lined out, and also reviewed by an attorney is really important. So that way we can look at it and see, will this be misinterpreted in the future? It also offers legal protection. There's a ton of provisions that go into a contract that are specifically for legal protection. A good example of this is an indemnification clause. That's something we always specifically look out for to ensure that there's a mutual indemnification clause, which is a clause that, for example, if you are a party planner and you contract vendors who are going to provide food, catering, decorations, things of that nature, you are entering into a contract, your company enters into a contract with, let's say, somebody's going to install a balloon installation. An indemnification clause is going to protect your company. Say that balloon installation topples over at the party and injures somebody. They can now, if that person is injured, they will bring a claim against your company because you were the event planner. That indemnification clause between you and the vendor who set up the balloon installation is going to protect you, because they will have to indemnify you for any claims that resulted from their negligence. So that's just a simple example to explain to you how an indemnification clause will come up in the future as a legal protection. Another really important thing is defining the terms of payment. So you want to lay out when the payment will be due, how it will be paid out. Is it monthly? Is it weekly? Is it as services are provided? It's just a really important thing that you want to lay out. And also we can put in those provisions what happens if payment is not, let's say, received in 5 to 10 days. That's we will say, okay, in 5 days, we'll give you notice. If it's not received within 10 days, then we have a breach of contract, and then we can pursue our remedies. So it's just really important to lay that all out and have it in writing. And then also it helps maintain good relationships between the parties because it doesn't leave much room for, personal issues. It's just laid out factually what we agreed to in writing, and you could kind of always defer to your contract and say, hey, this is what we agreed to in writing. This is what I'm going to stick with. It's not personal. You can always amend an agreement too, which is something nice, that if you guys come to an agreement that you want to change some terms, we can always draft up an amendment to that agreement and kind of, make changes as you see fit as, business develops. Does anybody have questions on any of these items? No? So what are we trying to accomplish with a contract? So accuracy in each party's rights and obligations stated as clearly as possible. Like I said, our goal as attorneys is to look at a contract and see if it has room for misinterpretation in the future. That's what we're trying to avoid. So that way it's clear, concise, and we don't have disputes in the future of what the parties intended. The goal is to have the parties' intentions clearly written. So this is a really important part. There is nothing wrong with a fair agreement. A lot of times we'll see clients wanting to have a one-sided agreement. The whole idea of a contract, again, is equity. So we want to avoid writing a one-sided agreement because likely it's never going to be accepted. So some key points in this is to anticipate what the other party needs and give as much as you can without compromising your position. So that's an important concept because you do actually want to offer some things to the other side that, for example, aren't as important to you, but may be important to them. So that way you have more leverage in your negotiation when you have certain terms that are very important to you. Give them a little something off the front end and they'll be more willing to negotiate with you. So this starting off on the offset with a more fair agreement minimizes negotiation, argument, and confrontation. So it saves time and legal fees. So yes, if we draft an agreement for you with all your terms written in it, sure, we can do that, but there's going to be more back and forth, a lot of revisions, a lot of red lines. And so to avoid legal fees like that, just going back and forth nitpicking, it's always good to just start off with a more mutual agreement. A one-sided contract, when each party has roughly the same leverage, usually ends up back in the middle. So that's, again, with the concept of equity, is if you guys both have the same leverage power, nobody's really going to win at the end of the day. Nobody's going to be willing to give on their terms. So again, it's always good to start in the middle because that's usually where it ends up. So startup agreements, when you are starting a company, for example, the first place you're going to start is with your formation documents. If you're starting a company, this is either for a corporation, a limited liability company, or a limited partnership. Any one of these types of companies are going to require formation documents. So this is where you're going to start. What do they contain? They're going to contain just the basic information about your company. It's going to start with the name of the company, the address of the company, the agent for service of process, and things of that nature. So the initial filing documents are actually very bare bones, and you don't need much in them. They're also filed with the Secretary of State. If you're in California, you could just do that online. It's a pretty easy process just to get that initial filing going. Also, these take about a week to 2 weeks for the initial filing to get back. So just account for that. Sometimes people think that their company is going to get filed very quickly, but it sometimes takes a couple of weeks to get that done. So if you need it done by a certain date, make sure you start ahead of time and kind of get those filings in when you need to. Okay. So this is a really important part about forming your company, is to think about the governing documents. So the governing documents are kind of exactly what they sound like. They're going to be the documents that govern how your company is ran. And it's, once a company has been properly formed, The company now is its own entity, separate from the person who owns it and operates it. So this is a concept that you have to keep in mind, is that now that you've formed a company, it's no longer you, it's the company is its own entity, and it kind of has its own rights, and it's governed pursuant to the California Corporations Code. So you can no longer think of your company being just as yourself, it's its own entity. And so when you operate on behalf of a company, it has to be in the best interest of a company. Okay, so why do we need governing documents? They set out the rights and responsibilities between owners of the company, management, and third parties. Because of this, we need governing documents which are an integral part of any company or partnership. Governing documents set out the company's purpose and how the company will be ran, how the members and the shareholders of the company will be added or removed, which is a pretty important part of a company. You don't want to have that left to just one person. For example, it's a kind of a contract between the company and its shareholders of how it's going to be ran. And the governing documents are going to go ahead and set out, for example, how shareholders and members can vote to add or remove members of the company, or how to transfer stock, things of that nature. When you're starting up a company, it's important, if you have investors that you're going in with or partners, that you guys determine the split of shareholders and votes necessary to take actions on behalf of the company. Again, the idea is to promote equity and to ensure that the company is not being ran with the best interest of a certain person, rather that the best interest of the company is being taken into account. So what are the governing documents? For a corporation, it's going to be the bylaws. For a limited liability company, it's going to be an operating agreement. And for a limited partnership, it's going to be a partnership agreement. These are all different names and they have different provisions within them for the same idea, which is the contract that's going to govern your company. For example, if we're talking about bylaws for a corporation, if the bylaws state that a 51% vote or more is required to add or remove a director, and two shareholders have 30% of voting shares, and the third shareholder holds 40%, the two shareholders with 30% can jointly approve the addition or removal of a director. But that shareholder with 40% cannot unilaterally make the decision. Again, it's important to think about these things when you're developing your company and developing who's going to be involved in it, and determine how it's going to be ran, just to ensure that the company never gets out of your control, or it's not what you intended, and then one person has more control than the other two investors, for example, the other two people who you're partnering with. It's just really important to think about these kinds of things at the onset when you're drafting these original governing documents, because once they've been made, you're going to have the vote of the other shareholders to make changes, to make amendments to these governing documents. So that's why it's always important to think about it before and then draft the documents accordingly, because once it's set and they're signed, you're going to need the permission and the signatures of those other two shareholders to make any changes. So it's just something to think about. The ultimate goal is just to ensure that the company is being ran in an orderly fashion. And it's really important to note that these provisions can actually be tailored to exactly what you want and need. As like the initial shareholders, directors of the company, you kind of have all the control in how you want this to be ran. So it's really important to know that you do have the flexibility to kind of put any provision you want and have it ran how you want it to be ran. Okay, so for shareholders agreement, who needs it? So shareholders agreements are for corporations. These are people with who have put probably capital contributions into the company. It's important to note that, for example, typically a shareholders agreement will be aligned with your capital contribution. So if you put in 50% of the capital contribution, you get 50% of the voting shares. However, it's also important to note that you can change this. you can ensure that you keep the voting power, even if your membership interest is reducing. LLCs don't need one because they don't have shares. So you don't invest in the same way. Instead, you have membership interests in an LLC. So shareholders agreements are only for corporations where you have shares. So shareholders agreements will also contain restrictions on transfers of shares. This will dictate how you can buy and sell shares of the company. And we can also put provisions in there, for example, if the initial shareholders have shares of the company and they want to sell, we can put a provision in there that requires them to sell back to the company or sell back to the other initial shareholders. That way they can maintain control of the company. If that's something that's important to you, we could put a provision in there that specifically requires that they be sold back to the initial shareholders. Again, this is another way to just maintain control of your company. So non-disclosure agreements are non-disclosure agreements are another really big sector of corporate agreements that we deal with all the time. So when do you need it? You need it when you're disclosing confidential information to third parties. An NDA can also be referred to as an NDA or a confidentiality agreement. So what does it contain? It contains terms on what information needs to be kept confidential, and there are some exceptions that exist to that. So a non-disclosure agreement is a legally binding contract that establishes a confidential relationship between two parties. The party or parties signing this agreement know that they're going to be sharing some sensitive information with the other, so they'll want to make sure that they're protecting this information by signing a non-disclosure agreement. They're really common for businesses entering into negotiations with other businesses because they allow for the sharing of sensitive information for the purposes of negotiation and establishing a business relationship without the fear that it will end up in the hand of competitors. So you don't want to be sharing your information to other businesses, especially if they're in your industry, without first getting a non-disclosure agreement signed, because it's going to protect your confidential information, and then you can disclose freely for the purposes of figuring out if it's going to be a mutually beneficial relationship, while knowing that your information is still going to be protected. A good NDA should detail exactly which information is protected under the agreement. So here we want to be as specific as possible to the types of information that you're going to be disclosing that you specifically want to remain private. So a non-disclosure agreement can be overly broad either, where it's like everything you say is confidential. And there's also some exceptions that exist. For example, if that information that you're sharing is already made public, then that can't be covered by your non-disclosure agreement. It has to be something that's not made publicly available already. So your proprietary ideas, inventions, things of that nature will all be things that we can cover in a non-disclosure agreement. And it's really important to just be specific, so that way there's no ambiguity into what you meant by, A, B, and C. You want to be clear. These are the things I'm telling you that are going to go ahead and be covered by this non-disclosure agreement. And that way it's all covered in writing. Sometimes you'll even want your employees to sign a non-disclosure agreement. This is perfectly acceptable to have your employees sign a non-disclosure agreement because they will be working obviously within the company. They're going to be exposed to a lot of proprietary information and things that you don't want to get out to competitors. So it's fine to have your employees sign a non-disclosure agreement. There are two primary types of non-disclosure agreements. There's a mutual non-disclosure agreement and then a unilateral non-disclosure agreement. A mutual non-disclosure agreement is where both parties agree that an exchange of confidential information will occur. So both parties are going to go ahead and uphold the same promises to each other of not sharing the contents of their conversation. A unilateral non-disclosure agreement, for example, would be kind of like when you would have your employees sign, because you're, as the company, disclosing the confidential information and the employee is receiving it. So here, this is where when only one party is disclosing confidential information to the other, and the receiving party is the only party that is going to uphold the non-disclosure agreement, uphold the confidentiality of the information. Okay, so website agreements are something I also wanted to touch on because they are legally required. So they are, if you go on a website, you see the little terms and conditions kind of pop up on the side where you have to accept it before you continue on using a website. It's essentially a contract with any website visitor. So when you are clicking accept, you are actually accepting the terms and conditions of the contract of the website and how it's going to be ran. So a privacy policy is legally required, and it helps protect the company by ensuring compliance with state and federal laws regarding privacy of your information, that is. So a privacy policy is a statement that describes how a website is going to collect your information and how it uses and manages that data. The type of policy usually includes a description of the who, what, where, and why of your data collection process. The key with these privacy policies and website agreements is just to clearly disclose and state what you're doing with the information. So when they click accept, your company is protected with how they're using that information. As long as it was fully disclosed and your policy is in compliance with the state and federal laws, your company will be covered for any privacy policy claims. So that's just something I wanted to touch on. It's really important because if you're going to have a company website, it's important to have a compliant privacy policy and make sure that that little pop-up comes up and you accept that to protect your company for privacy policy claims. So to end it, it is impossible to unsign a contract, so do all your thinking before you sign. This idea is pretty simple. Once you sign a contract, it's binding, and even an attorney can't just get you out of a legally binding contract. Those terms, you're bound by them, and it's important to think about the consequences of what you're signing and the terms that you're agreeing to beforehand, because an attorney can't just get you out of it. So it's just important to do all your thinking before you sign. And once you do, just know that it's legally binding. And yeah. So do we have any questions?
First off, thank you.
Of course.
So appreciate that. That was a lot of information. I'm sure we do have some questions. I know I have some questions. So why don't we go ahead and open it up to the audience. And for those of you who did join us a little bit late, I'll just go ahead and put more information about our incubator in the chat so you can see more information about that. But feel free to unmute yourself and ask your question.
Can you hear me?
Go ahead. Yeah.
Hey, it's Loretta. So I have a question. So with the company that I work with, I signed a non-solicitation clause, a non-compete clause. So if I were to start my own company and then if I did not solicit patients to my own company, but let's say they were former patients that requested on their own to come to me, would that still be considered solicitation? Do you know what the definition of solicitation might include?
So I heard the first half of your question a bit in between. It was kind of hard to hear you. If you could just repeat the second half. I know you signed a non-compete, non-solicitation agreement.
Yeah, and then if I don't solicit them, but they still request to come work with me, would that still be considered solicitation? What would the definition be considered with solicitation with regards to me making contact with them versus the other way around?
Mm-hmm. So that's going to be the solicitation part versus the non-compete. So just because you're not necessarily soliciting them, that doesn't mean you're not directly competing with them by taking, it depends on the situation. I would have to see the actual language, but the solicitation is you going out of your way for them, but it could still violate the non-compete if
okay, they actually didn't put non-compete. They actually didn't put non-compete in the language. They actually just put non-solicitation. I kind of assumed it to be a similar type of thing.
Mm-hmm. Oh no, I mean non-compete and non-solicitation are slightly different, but usually it's in the same provision. But non-compete would just generally be you being in the same industry, doing something that's directly adverse to their business. Non-solicitation would be you soliciting, for example, their employees or something of that nature.
Got it. Okay, cool. Thank you.
You know, on that topic, how much weight does a non-compete really hold in California? I've been told that it doesn't hold that much weight anymore. Can you talk about that?
Yeah, so non-competes are, in California especially, probably one of the least stringent, just because there's a smaller scope that you can have for a non-compete in California versus other states, and shorter time periods, shorter, smaller radius for these non-competes. So generally their enforceability has diminished also, just because the way the California laws are, they're very employer friendly. So it's kind of depending on how you word it, it can have some weight, but in California, they haven't been holding up as much. We do usually put a non-compete, non-solicitation in every agreement though. It's important to include, but the enforceability is definitely the most diminished in California. And so that's going to be diminished by like scope, time frame, and also to what extent you can limit somebody's non-compete or limit somebody's ability to compete with your company and to solicit employees.
Yeah, very interesting. Another statistic I know that about 40% of people that do decide to become entrepreneurs came from that same company or that same industry. So it's like they've learned enough. They maybe hit a prime age of about 40, 45, decided they can do it better than their boss, and then they started their own business. And that is a very typical route, rather than the 19 or 20-year-old Mark Zuckerberg building a startup from being a high school or college dropout.
Yeah, definitely. I mean, in that regard, you working in the same industry, for example, if you're in tech and you come up with your own tech business, it's not necessarily going to collide with the non-compete, non-solicitation. And in that regard, it's the free market to be in an industry, like that's not really going to be limited by non-compete, non-solicitation. It's more so like a very niche situation where that non-compete, non-solicitation will affect you.
Okay, other questions? I know while we're waiting for other people to have their questions, I do have a question. And so regarding the whole, there was a part, I'm not sure what it's called, but I'll go ahead and describe it. So if someone says, hey, here's an offer, I'm giving you an offer, like a buyout offer, and the other person says no, and then it comes down to going into court, and then they said, well, I gave them the offer, and we've decided to do a verbal contract, and the other person says, no way, this was not, I never said that we would do a verbal contract. How much weight does that hold? Because I mean, that seems kind of a sticky situation, because if you want to keep things in writing and the other person is arguing that there's been a verbal contract out there, and that's not true, I mean, how do you defend against that?
So I think the word you were looking for was the consideration. Yeah. And so when it comes to offer and acceptance, so an offer, like you said, has been put out there. So now the power is in the hand of the acceptor to either accept, deny, or maybe respond with a counteroffer. A counteroffer, like I said, will go ahead and revoke that initial offer, and now they've become the offerer. You have to accept their new terms. So when it's a verbal offer and acceptance, that's totally legally binding. However, it's not going to become a full contract without that consideration. So that is either, for example, like you said, I offered you a buyout, and let's say the person didn't accept it, but I'm going to go to court and say, oh no, they accepted it, so now they have to accept my buyout, right? The consideration would be the payment. So that's kind of almost like proof of acceptance or detrimental reliance. Did they do something that shows that they accepted this offer and you relied on it? Did they pay the money? Then okay, then there's consideration, there's something that binds it. So just the offer and acceptance itself, the terms of that would be legally binding if there was that consideration to make it a full, complete contract or some proof of detrimental reliance to kind of glue it all together.
Okay, I do see some other questions in the chat.
Hi, I have a question. So when I'm talking to a potential co-founder with respect to my startup idea, and then we decide not to go work with each other, is that idea protected under the IP laws, or does it have to be a patent, or do I have to make him sign an NDA for any protection?
Yeah, that's where the NDA would be super helpful. It happens all the time. You know, businesses enter into those initial conversations to even see if they're going to have a mutually beneficial relationship or if their businesses even work together. And a lot of times they don't end up going through with the actual, you know, whatever business relationship they set out to have. Having that NDA signed going into the conversation is what's going to protect you from having any of that information disclosed. So yeah, that's when an NDA would come into play. And again, we always recommend signing that before you even have those conversations.
Okay, thank you. So the idea is in itself is not protected, right? It can be duplicated if you don't sign an NDA.
Well, it's not that it can be duplicated necessarily. It's more so that it's it can be disclosed, and it can. A patent would be more so for duplicating. It depends on what you're actually talking about when it comes to the idea or the invention or product or whatever it is. That's more of a patent to protect it from being duplicated. An NDA is going to protect that disclosure from, for example, say, I'm not exactly sure what your business is, but if you have an idea that can be disseminated to competitors if you don't have an NDA to protect like your conversations and also what you disclose to whatever business it is that you've had or like you said, a co-founder, the initial ideas, the conversations, that's what you could protect with an NDA.
Right.
But
Thank you so much.
And I did see one in the chat about early termination of an agreement.
Yep.
So termination and the term of an agreement, this is like a really important provision of a contract. So early termination, usually you can govern how that's going to be done. So in that provision of the contract, you'll put, for example, this contract can be terminated by either party for any reason or no reason. So you would put that language for any reason or no reason, so that way you have the flexibility with 30 days prior written notice. So the term of the agreement is going to be 3 years. We set that term. But say you want early termination, that's something we're going to put in the provision in a provision in the contract itself to govern how that's going to be done. You can also have a contract that you sign that, for example, says it cannot be terminated by buyer. It can only be terminated by seller. Early termination. For example, if buyer isn't making their payments, seller will typically have that built-in provision that seller can terminate the contract early for non-payment. So it's kind of going to depend. I don't know if you're talking about a specific situation, but typically these terms will be built into the contract, the early termination, how it can be done, who can do it, and notice, like how you're supposed to give notice to the other party. That's all something that we would build into the contract or should be in the contract already.
Okay, there's another question. Is there any advantage of registering your startup as an LLC instead of a corporation?
So LLCs and corporations are just different businesses in general. So I guess if you can be more specific about your question when you say advantage, I guess more particularly, what would you want to lean one way versus the other?
Yeah, so when you, as a tech startup, when you apply for incubators or venture capitalists, prefer you to register your company as an LLC instead of a corporation. I just wonder why that is, because I don't know the pros and cons of each.
Oh, okay. I'm not actually particularly sure why venture capitalists would have a a preference, but for a corporation, like we said, there's shareholders, right? So shareholders are going to have capital contribution that they're putting into your company. And then that's voting power for how the company is going to be ran. So that's something to think about when you're doing a corporation versus an LLC. It's going to be shareholders have rights and voting power on how the company is going to be ran, whereas LLCs don't work that way. LLCs are membership interests. So I think it's just really venture capitalists may be interested in that aspect of having control of how their money is being spent, essentially, because they're investing in the company, and shareholders will get voting rights, and you need the voting rights to make any decision on behalf of the company. So it kind of is a different dynamic of how much control and input you get into how the company is being ran.
Okay, thank you so much.
Mm-hmm.
I'm curious, is there anywhere that the shareholders percentage is documented somewhere, either on the Secretary of State page or anywhere else, or is that just really an internal document between the two party members or party members of the company?
Mm-hmm. So yeah, it is an internal document, but it is going to be documented in your so you'll have a packet of corporate documents that's internal. And if, for example, you have a stock ledger and a stock certificate, those are issued at the beginning of the formation of a company. So whenever we form a new company, we provide the stock ledger and the stock certificates. That's the official documentation of the shareholders' percentages and how many shares they own. So the only thing that will be publicly put on the Secretary of State is going to be how many initial shares are distributed. So for example, if you have 1,000 shares distributed, your stock ledger will show, if you have two people that have 50-50 in it, then one shareholder has 500 shares, the other shareholder has 500 shares. And so, but for example, you can issue more shares than what you initially give out. So you can have 1,000 shares initially issued with the company, but you only give out, let's say, 200, right? So then that's all going to be documented in your stock ledger, and it's going to be evidenced by your stock certificates.
Okay, so that's not really public either, the stock certificates?
No, those are internal corporate documents, but they are important. You have to have them, and you have to have them signed as well for your own corporate book, and they are enforceable.
So when someone separates from the company, is there a form that needs to be filled out for that as well?
So what you'll do in that situation, depending on, for example, where their shares are going to be transferred, if they're going to be transferred, if there's two people in a company, let's say, that one party leaves the company, they may be transferring their shares back to that other party, right? The party that's remaining with the company. What we're going to do is cancel their stock certificate. We'll cancel that out, and then we'll issue a new stock certificate to the shareholder that stayed with the company. And then you update the stock ledger to show stock certificate 2 has been canceled, stock certificate 3 has been issued, and now they have 200 shares, whereas they had 100 before. So that's all just kind of documented, and like I said, it's enforceable. So you want to make sure you're keeping your records clear and signing everything.
And when you talk about ledger and stocks, these are things that also, I guess, could have a paper trail, because they're, according to the IRS, that this is considered equity, right? This would have to be perhaps reported for the IRS, or reported, or handled some way in terms of your accountant.
I'm not particularly sure if they have to be reported, but I do know that you have to keep the paper trail, like you said, and I think dividends and things of that nature is what you're maybe referring to. That aspect does need to be reported when you're getting returns. Those dividends need to be reported as income.
Other questions? Let me take a look through our chat here and just see if we make sure that we got everybody.
You were talking about business partners earlier in the discussion. Do you have any recommendations of resources or any books that talk about either how some businesses don't succeed either with partners or without business partners? The like common causes of why they would overall fail?
Why business partnerships would fail? Or, well, I think that goes back to the whole idea of the contract is between the shareholders, for example, and the company. So really, you're just setting out, and you're also setting out how your partners are going to come to consensuses on decisions for the company. So what I would say, the reason why sometimes these partnerships will fail is because their governing documents weren't drafted looking ahead, like, hey, what if we don't agree on something, right? These kinds of things need to be discussed ahead of time and put into your governing documents, because it's all going to come down to voting for the purposes of equity, right? We want to make sure that we're writing these documents so that way when issues come up in the future, they are clearly written how we're going to handle it. These are the documents of how your company is going to be ran. So I would say that's probably the biggest thing I would say is two people don't go into the company with the same idea in mind, or they do at the beginning and then they have disagreements in the future and it's not properly documented how these are going to be resolved. So I would say that's the main thing, but also I don't think there's necessarily an advantage to starting a company by yourself versus with a partner. I think that just has to do with your relationship in general with that person. Do you trust them? You know, that's more so maybe what I would say, because the contract itself, the governing documents, they're going to lay out the rules, but it's not going to change the relationship you have with the person that you started a business with, for example. So I would just say that's a really important thing to look at before you go into it.
That makes sense for sure. Thank you.
Mm-hmm.
You know, this brings up another question about buy-sell agreements. If someone doesn't have their buy-sell agreement, what happens if the other partner just decides that they just want to not be a partner and not do anything anymore? How do you get them out of the company? Do you get out of the company?
So when you say your buy-sell agreements, are you talking specifically?
Oh, two partners, they work, they're partners, and then one partner says, you know, I just don't want to work with you anymore. And you can pay me 50% of from now on forever. Oh. At what point can you cut them out, or are you just kind of in trouble?
So yeah, again, this is going to come down to how you draft your governing documents. But yeah, you can buy out. You will buy out that partner and say, okay, give them back their capital contribution, and then they're out of the company. So if they no longer want to be a part of it and participate, you buy them out, and then you're able to kind of clean your hands of that situation and then just document it with the, like I said, the ledger, everything, cancel their shares, transfer them back to you. Or for example, if you're bringing in somebody else, you would just document all of that, amend and restate your initial corporate documents with you as, for example, if there's just one person left, you as the sole member, the sole director, and that's how you would do it.
What about if the person said, no, you could just pay me forever and I don't want to be bought out? Does that really, I mean, I would almost say that's probably why you need to have a lawyer to get your agreements in the first place.
Yeah, but definitely.
But of course, but what happens in that situation? I mean, is there any way to get that person out?
There might be. That's what it would really have to depend. I'd have to review the corporate documents of the specific company, see what you guys have written, what's in there. There might be, but that probably would go to like corporate litigation. On the transactional side, we don't really, we don't take it to that point, but you might have to go to a corporate litigator at that point to, if buyout doesn't work, that would probably be like your next step, is you'd have to go to a litigator.
That's what I think too. it's always important to have these, and just I'm a big proponent of this, to have your contracts in place first. These are very, they might sound like a few $1,000s now, but they're going to cost you millions of dollars later in litigation. So
yeah, definitely transactional is the less expensive option. If you can just get your contracts in order from the get-go, litigation in California is so expensive.
Yeah. Let's see. I did see another question here. I don't think it's a legal question, but I'll go ahead and state it here. Having a business plan is an important document to have in a startup stage. I can answer that from the incubator perspective, but let's just see. Let me ask our expert here first from a legal standpoint. Would you say that that's more of a business operations, or would you say that that's anything to do with legal?
I would say it's definitely leaning more business operations, but the value I can see from a legal perspective would be to show intent of the parties. If it shows you've discussed a plan between you and your partner, this is kind of the direction you have going. If there's ever disputes in the future, it will definitely go to intent and what you guys had previously discussed and agreed upon. That's where I would see the value from the legal side.
Yeah, so from the incubator side, or basic business operations, to be on the same page is really important, and to talk about what your plan is, which actually trickles down into a legal document, which is the operating agreement. And the operating agreement is more or less like who's going to do what. And I'm sure our resident lawyer can talk about a little bit more about that part. But the business plan is really important in the beginning, just to kind of set up a little bit more of a direction. What we teach in our incubator is more of a lean startup methodology. It's not so much about creating the entire business plan, but kind of creating an idea where you want to go, and actually then talking with more customers to dictate which is going to be your business plan or your business model, how you're actually going to make money. And then from there, you get it more solidified. The business plan isn't really required until you get to the investor stage. That's the only party that's really interested in the business plan, because it doesn't matter. I mean, it could be two people working together, and they just need to be aligned on the same vision. And then again, that's where it comes down to the operating agreement. So I don't know if you want to talk a little bit more about the operating agreement and why that's important.
Yeah, like you said, the operating agreement is really important to dictate what value you're bringing to the company, and like kind of what is how the company is going to be ran. And also membership interest is really important too. That's again going to govern decision making, which is what's really important. How the power dynamic is when it comes to membership interest is going to dictate how your company is going to be ran. So if you're working with others, if there's 2 or 3 or 4 members in an LLC, it's really important to kind of get that dynamic written down. And so that way there's no disputes when it comes to decision making for the company. That's all going to be spelled out in the operating agreement. And thought I saw a question pop up, but yeah.
Oh, excellent. All right, we have time for maybe 1 or 2 other questions. Does anybody else have any other questions? And do we have your contact information? I think we need to get your contact information up there.
Oh, okay. Can I put it in the group chat? Will that work?
Please.
Okay.
Yes, please. Yeah.
So I will put my email address right here. And if anybody has any questions, please feel free to email me.
Thank you.
That is my direct number as well.
Perfect. All right. Well, if you don't have any other questions, again, I'm just going to say thank you so much for your time. I really appreciate it. And this is great information. I think a lot of people are going to benefit from this information. And this is, again, get your ducks in order before going into business.
Mhm. That's so
So you
important.
feel-
Also, the relationship you have with the people you're going into business, that's something to really consider beforehand, because a contract's only going to dictate the terms and conditions. It's not going to change the person who's on the other side of that contract. So just keep that in mind.
Definitely. Okay. For those of you who have any other questions, again, Alyssa's contact information is in the chat. I did put my information as well in the chat, and you can book a time to speak with me. You can visit our website, learn a little bit more about our incubator. In 2 weeks from now, same time, 6 o'clock, we are going to be having a guest speaker talk about how he raised over $100,000 on Crowdfunder. So if you're interested in starting up a business, or whether it's a product or a service, and you want to learn how he raised, or you can also raise about $100,000 or more, please join us. And we're going to talk about all those tips and tricks. All right, everyone. Thank you so much for joining us.
Thank you.
Have a good evening.